You are welcome to HN What's Your Say? The #1 listening show where we discuss real issues with real people like you. We are still featuring R. Kelly. Real name Robert Sylvester Kelly. Also known as the R&B King. After saluting the appeal court judges and introducing herself, R. Kelly's lead attorney Jennifer Bonjean started off by giving the court a quick flashback of what transpired during the Chicago trial, and to be specific, the charges R. Kelly was indicted for, those for which he was found guilty and the others where he was acquitted. And then she crossed over to the sentencing, which has been her major concern since, stating that the 240 months, which equate to 20 years in prison for R. Kelly, was way above the guideline range. Bonjean broke ice in the courtroom when she disclosed that the Chicago District Court Judge Harry Leinenweber had actually read the guidelines and calculated through, but then adamantly and without cause decided 20 years was what the R&B King deserved. By this, Bonjean implies that the district judge had completely no regard of the guidelines he carefully read when he chose to issue the statutory maximum of 240 months, shattering R. Kelly's hope for freedom anytime soon. She goes on to state the defense's position, suggesting that the district court's justification for the adopted guideline range lacked sufficient factual basis. Attorney Bonjean informed the appeal judges that the district federal judge relied on already acquitted obstructive conduct and today's guidelines, which should not have a retroactive effect on crimes allegedly committed decades ago. Addressing the acquitted conduct, Bonjean was intercepted when she mentioned the federal judge's vague statements that suggested he still believed R. Kelly obstructed justice even if he was acquitted for the same. The argument was whether his mentioning it meant he actually did base on it to come up with his own sentencing range. Bonjean, however, deflects, suggesting whatever the circumstances in which Harry Leinenweber mentioned this, and whether it is or isn't what he actually based on to issue the 20-year sentence, there was no factual basis for him to opt for an above-guidelines range. As though to agree with attorney Bonjean that indeed the sentencing was botched, one of the appeal court judges did ask her whether she believed that if this matter was taken back to sentencing, her client would very likely be disadvantaged, basing on the fact that the 20 years she is concerned about could easily be repositioned to be served consecutively with the already disturbing 30 years that were issued in New York. Asked whether her client realizes that, Bonjean responded saying if the resulting net sentence ended up more significant than the current, this would be in a way abusing the right of her client to appeal, which she doesn't think the judge would want to do. The judge insisted on this possibility, suggesting the trial judge could choose to start over again from first principles, and restructure the sentence afresh, issuing it as a consecutive one, making it even more consequential or harsher than it already is. It's just so amazing how even the appeal court judges are already sensing that the trial judge may choose to act maliciously and prejudicially if given a chance to resentence the R&B King. Bonjean, who responds with intense emotion, however, did make the concerned judge understand that with the already existing 30-year sentence in the Eastern District of Brooklyn, which is in a way a life sentence for R. Kelly, there is almost nothing to lose, for if this remains as is, R. Kelly will likely die in prison. By this, Bonjean meant that it still would be better a reduced Chicago sentence, consecutive or not, for she has to do all in her ability to overturn the New York 30 years anyway if R. Kelly must return to freedom during his lifetime. That is the reality we are dealing with, she concluded. Again, when the appeal judge intercepts and speaks on the fact that the trial judge may have the freedom to refer to the amended current guidelines, Bonjean speaks of the ex post facto principle of law that prohibits amendments which retroactively punish criminal behavior from the past. She reminded the court that for the trial judge to go above the recommended guidelines, there must be evidence of an aggravating factor which was never cited, making his decision a pure violation rather than a proper basis for going above the sentencing guidelines. And left with only 1 minute, attorney Jennifer Bonjean decided to quickly move to the issue of the statute of limitations, which according to her the court should be well versed with. Bonjean begins by reminding the appeal court judges that when Congress made these laws, they intended that they work for the future and not retroactively like the district trial judge decided. Before she could say more, her time was up and she decided she would make more arguments during her rebuttal. At this moment the state attorney took the floor. While we hoped that the state attorney would explain why he believes that 240 months were actually what R. Kelly deserved, and stating what he was supposed to receive by law, Sounding rather unprepared, he immediately strayed into speaking for the district trial judge and suggesting that he started with the defendant's proposed guidelines range, and then went above those guidelines range upon a thorough explanation of the 3153A factors. To explain this, he added that the judge's decision to opt for an above-guidelines sentencing was the court's finding that the defendant's conduct was simply horrible, horrific, and deserving very serious consequences for Mr. Kelly. By mentioning this, he actually did expose the prejudice we have all along been discussing. It's not supposed to be the emotional interpretation of the gravity of defendant's actions to guide the sentencing but the supreme law. While the judge may have felt that R. Kelly was so bad, he still needed to follow the supreme law, and all he had for this was the guidelines and not his own emotions to guide him. As though not ashamed of repeating what Bonjean had already challenged, he also did agree that the presumption that R. Kelly had exercised obstructive conduct was one of the many the trial judge relied on, which interestingly he was acquitted for. This prompted an interjection from the appeal judge, whose mind was suddenly triggered by what she had just heard. By this time, the state attorney was already stammering and biting his tongue when he shamelessly stated that in fact the trial judge on his own found that obstructive conduct had occurred even if the very same court determined that it hadn't. He too admitted that indeed the sentencing transcript is ambiguous in order to deflect what the appeal judge was reacting to. Just like the government witnesses did before and during trial, changing statements from time to time to suit the narrative, the state attorney was technically withdrawing what he had just said only because the appeal judge seemed uncomfortable with it. Very funny. Left with little or no defense for his trial judge's decision to issue an above-guidelines sentence, the state attorney decided to say it was only based on the seriousness of defendant's conduct, which surely doesn't make any legal sense. Meanwhile, he isn't sure himself why the judge did this, because he says he only believes that the judge could have arrived at the 240 months. And I repeat, could have arrived at the 240 months basing only on the seriousness of R. Kelly's crimes. He was generally fumbling with his explanations and failed miserably. Asked whether he was trying to mean that Judge Leinenweber actually did find the obstructive conduct viable outside court and on his own and based on it to issue the 240 months, the state attorney answered, "Yes, Your Honor." He then moves quick to defend judge's actions, quoting that he is actually allowed to consider acquitted conduct for as long as it is proven by preponderance of the evidence provided. And that's exactly what the district court did here, he concludes. To further justify this, he reflects on how allegedly R. Kelly spent hundreds of thousands of dollars trying to recover tapes, calls R. Kelly allegedly had with witness Jane's parents during the course of the investigations, the family's non-participation in the grand jury during the subsequent 2008 trial, payments allegedly made to Jane's father during that period, and many more events he says he didn't have to mention. Moving to the statute of limitations issue, he states that the prior statutes of limitations were anything less than for the life of a child. By saying this, the state attorney tries to ignore the intent by Congress when they enacted the laws, but the appeal judge is quick to bring him to check and make him understand that this is actually important. Clearly basing on what the state attorney said inside the appeal court hearing, he, like the trial judge, just have no respect whatsoever for the statutes of limitations which Congress enacted as safeguards for justice. Asked by the appeal judge to refer to the second step of the interpretation, the state attorney hesitates and suggests there is no need for that, since the first step already allows the trial judges to violate the statutes of limitations as they may please. This was very disappointing to listen to, and to learn that the state attorney actually feels the government and trial judges are and should be above the law. After this submission, Bonjean took the floor again with a rebuttal, which we will be bringing to you in our next video release. If you wish to take part in a live interview on this channel discussing any of these topics, let us know by emailing us on sashahnnewsroom@gmail.com for scheduling. That is all we had for you today on HN What's Your Say. To keep updated whenever we post a new video, subscribe to this channel now. Also remember to hit the bell icon and enable notifications. And feel free to share your opinions with us in the comment section below, and let us know if you would like us to publish your views in our next release. We value all our subscribers' opinions.